start by addressing the procedural requirements. As the court knows, Ms. Benefield sought judicial immunity pursuant to Florida's Stand Your Ground statute. She alleged, and we had the obligation to establish, that there was an objectively reasonable expectation that she would suffer great bodily injury or death, and that knowing what she knew about Douglas Benefield, the force used was reasonable. So to that end, as the court is aware, we established a prima facie case that the force used was justified. The state stipulated to that, and Your Honor signed an order so designating it. At that point, the burden shifts to the state to establish that the force used was not justified. That's what the statute says, and that's what the case law holds. The standard that the state has to meet to do that is clear and convincing evidence. So that leads us to what I think is a very appropriate consideration, Judge White, which is what are the parameters of a motion such as a Stand Your Ground motion? I would suggest to the court that was pretty well defined in the second DCA case of Bowie versus State. I'll give the court the cite at 292 Southern 3rd, 471, and specifically page 483, second DCA case 2020. The court there pretty much stated that the inquiry for the court is to entertain any evidence which establishes that the force that was used was not justified, which means, Judge White, that any other inquiries are irrelevant, specifically motive. Motive, a lot of times at a trial, is not required. It's never an essential element, but when it is available, it's a very powerful tool for the state to present to a jury. Abuse allegations, also irrelevant, as is Ms. Benefield's psychological state. Why are they irrelevant? They're still, of course, subject to the rules of evidence, even if the court entertained them, but the question then is, why would they be irrelevant? And it's our position, Judge White, that they're irrelevant simply because they are not material to the Stand Your Ground statute's requirements. As the court knows, the issue is, was Ms. Benefield in a place where she had a right to be? Was she involved in any criminal wrongdoing? And did she have an objectively reasonable fear of great bodily harm or death? So the case law supports exactly that. One of the benefits, Your Honor, of being in the Second Circuit is we have very well-defined case law on Stand Your Ground. And I'll cite to the court two things in particular that should apply across the board to this hearing, respectfully. The first is in Riggins versus State, which is in our brief. It's at 344 Southern 3rd, 625, page 626. Also a second DCA case in 2022. Therein, the court held that the trial court, this is a quote, the trial court is to assume all facts as true. Secondly, I would cite to the court, also in our motion, the case of Jefferson versus State, 264 Southern 3rd, 1019, again a second DCA case, 2018. Here's what the Jefferson court had to say in upholding the Stand Your Ground motion and immunity filed by the defense. Quote, "We are mindful that there will be situations where the accused is the only available witness to the events leading to an act that is claimed to be justifiable use of force. This may result in great difficulty for the state to overcome the accused's prima facie claim by clear and convincing evidence. But our result here is mandated by the text of section 776.032 subsection 4 stands your ground. In closing, Judge White, I think that the state will be unable to demonstrate in any capacity, much less by clear and convincing evidence, that Ms. Benefield, knowing what she knew on the day of this incident about DB, which is the objective standard, Douglas Benefield, was not justified in using deadly force to prevent great bodily harm to herself or death. Thank you.
Thank you, sir. All right, State.
State calls Tommy Benefield.
Judge, I suppose now we're into our omnibus motion and limiting reading.
And you're talking about your omnibus motion?
Yes, sir.
Under, hold on one second. I'm looking through. Do you want to go ahead and put whatever it is on the record related to
Yes,
Tommy Benefield?
Number 2, yeah.
Number 2. All right.
I had lodged an objection to any Benefield family member testifying without personal knowledge of or participation in the events immediately preceding the alleged homicide. I then followed that up with a discussion about testimony by non-expert witnesses who lacked personal knowledge and cited the Florida Evidence Code. And I also included in the memorandum for Your Honor the following. As the court knows, in a homicide case, the accused has the absolute right to open the door or keep it closed as it relates to character evidence. Only the accused can inject character evidence, after which the state is permitted to rebut it. It is the same thing with a witness's testimony under 90-404, Your Honor. Mr. Benefield is limited. The state can establish that Douglas Benefield had a reputation for peacefulness once it's attacked. The rule is very clear. So it has yet to be attacked. Mr. Benefield can only testify as it relates to the rehabilitation of character by the state for peacefulness to his reputation in the community. Mr. Benefield did not live here in this community. He can only testify to his personal perception of his cousin's reputation for peacefulness, which the Florida Evidence Code does not allow. That's our objection, Your Honor, respectfully.
Thank you very much. State.
And Judge, the state does not intend to elicit testimony about reputation.
Okay. This is a great example of what I was saying when we were talking about the hearing is I've heard your objection. I'm going to reserve on it because I don't know what these witnesses are going to say. I don't know quite where we're going. You guys know the case so much better than I do. So for now, I'm going to allow it, and I'll reserve at the end for, so keep making your objections. I'm going to reserve on those, at least this one.
Understood.
Some of them might be a more clear call, but we'll pour it all in the pot and see what we get.
Understood, Your Honor, and I might say I'm quite comfortable with the court proceeding that way. I have no doubt.
Thank you. But let me say this. Having sat on at both tables, you make every single objection as we go that you feel you need to make. But I understand completely you have just a general objection to all of that character evidence, the background. You want to focus on that particular day.
Yes.
Got it.